The 5-year regulation allows government entities to claim your property, and most older adults do not discover this until it is far beyond the point to take corrective action. If you are 65 or older, if you own your property, if you have any financial resources at all, you need to understand exactly how this regulation operates, because the individuals who are supposed to clarify it to you have a very strong motivation to remain silent. There is one specific legal instrument that can halt the entire procedure before it ever starts, but most estate lawyers will not mention it unless you request it by its exact name. I will tell you what that legal instrument is called before this presentation is over. The regulation itself is called the Medicaid 5-year lookback, but the title is misleading. It is not really about looking back. It is about imposing consequences on you for actions you took when you had no idea you were doing anything problematic. Here is how it operates. If you ever need long-term nursing facility care, and the average stay in this nation now costs over $18,000 per year, you will almost certainly deplete your funds. Therefore, you will have to apply for Medicaid to cover the expense. But before Medicaid pays a single dollar, a state caseworker will pull every bank statement, every property record, and every gift you have made for the previous 60 months, every single transfer, every check to a grandchild, every car you signed over, every dollar you moved. Then they calculate a consequence. The consequence is not a fine. It is something more severe. The state takes the total amount you transferred during those 60 months, divides it by what they call the regional penalty divisor, which in most states sits between 10,000 and 12,000, and the result is the number of months you are locked out of Medicaid coverage. During those months, you must pay for the nursing facility yourself at over $9,000 per month, even though the entire reason you applied for Medicaid is that you do not have $9,000 per month. This is the situation. You gave away the money. Therefore, you cannot pay. But because you gave away the money, the state will not pay either. So, who pays the nursing facility? The nursing facility does not care. They will sue. And the first asset they will come for is your property. Most people assume the regulation only catches large transfers. That is incorrect. The look back catches everything. A $400 Christmas check to your granddaughter counts. Paying for your son's wedding counts. Helping a grandchild with college tuition counts. Forgiving a loan to a family member counts. Selling your car to your nephew for $1 counts. Even charitable donations over a certain threshold can count depending on the state. There is no birthday exemption. There is no holiday exemption. There is no I did not know exemption. The federal annual gift tax exclusion, which clears throat, currently sits at $19,000 per recipient, has nothing to do with this. That is an IRS regulation. Medicaid is a completely separate system with its own regulations, and Medicaid does not care what the IRS allows. A gift that is perfectly legal under federal tax law can still trigger a full Medicaid consequence. Most older adults do not understand this distinction. Therefore, they assume their gifts are protected. They are not. Now, here is where it gets more challenging, and this is the part that devastates marriages from beyond the grave. If you are married and your spouse goes into a nursing facility, you might think the law protects the healthy spouse who stays home. There is a protection. It is called the Community Spouse Resource Allowance, and in 2026, it sits at $157,920. That is the maximum amount of countable assets the at-home spouse is allowed to keep. Everything above that number must be spent down before Medicaid will pay 1 cent. $157,000 sounds like a lot until you realize what it actually has to cover. Property taxes, home repairs, Medicare premiums, food, gas. medications, emergencies for the rest of the healthy spouse's life, which could be 20 years, which works out to roughly $657 per month. That is the calculation the state expects you to live on while your husband or wife is in a facility that is charging over $9,000 per month for the same time period. But surely the property is safe. The property is the one thing they cannot touch. That is what almost every older adult in America believes, and it is incorrect. The property is exempt while you are alive and using it. Therefore, Medicaid will not force you to sell it before you qualify. But the moment the Medicaid recipient passes away, a program called the Medicaid Estate Recovery Program activates. Federal law requires every state to attempt to recover the cost of care from the estate of any Medicaid beneficiary who was over 55 at the time benefits were paid. The recovery target is the property. The state files a claim against the estate. The heirs are told they must either pay the bill in full, often hundreds of thousands of dollars, or sell the home and turn over the proceeds. The average estate recovery claim in this nation now exceeds $74,000. In some states, it is over $200,000, and it is not optional. It is not negotiable. The federal government requires the state to come after the property. Therefore, the property your parents promised would go to the grandchildren ends up going to the state of whatever they happen to live in. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older law on the books called filial responsibility. These laws say that adult children can be held financially responsible for the unpaid nursing facility bills of their parents. For decades, these laws sat unused. But starting in 2012, after a Pennsylvania appeals court ruled that a nursing facility could collect $93,000 from an adult son for his mother's care, the floodgates opened. Therefore, the situation is not just that the state takes your property. The situation is that the nursing facility, after the state finishes its recovery, can turn around and sue your children for whatever is left. I will give you a real example. A widow in Ohio, age 78, transferred $45,000 to her daughter over a 4-year period. Birthday gifts, holiday checks, some help with a car repair. Nothing she considered unusual. She entered a nursing facility in month 47 of those 4 years. The state divided her $45,000 by the Ohio penalty divisor of $74.63 per month and locked her out of Medicaid for 6 months. The nursing facility billed her $9,200 per month for those 6 months. Total bill $55,200. She did not have it. The facility placed a lien against her property. She passed away 8 months later. The state then filed an estate recovery claim for an additional $140,000 in care costs. Her daughter received a letter informing her that the home she grew up in was being sold by court order. There is a strategy that some lawyers use to soften the impact when there is no time left. They call it the half a loaf. The idea is that if you or your spouse already needs care, you give away half of your remaining assets and use the other half to pay for care during the penalty period that the gift triggers. It saves something. It is better than losing everything, but it requires precision timing. It requires a specialized lawyer, and it has to be done before the Medicaid application is filed, not after. Once you apply, the strategy is finished. The older adults who lose everything are almost never the ones who plan. They're the ones who were never told planning was an option. They sat in a hospital room, signed a power of attorney, and started writing checks to the nursing facility with no idea that with one phone call to the right kind of attorney, 2 years earlier they could have protected the property, the savings, and the inheritance. Now, I told you at the start that there is one legal instrument most estate lawyers will not bring up unless you ask for it. Here is what it is called. It is called a Medicaid Asset Protection Trust. In 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont, there is also something called a ladybird deed, which accomplishes part of the same goal for the home. Specifically, a Medicaid Asset Protection Trust is an irrevocable trust. You move your property, your savings, and your investments into the trust. You no longer technically own them. The trust does, but you can still live in the property. You can still receive the income from the investments. You just cannot take the assets back out after the trust has been in place for 5 years. Those assets are no longer counted by Medicaid. The lookback cannot reach them. The estate recovery program cannot reach them. The property is protected. The savings are protected. Everything inside the trust passes directly to your heirs without going through probate, without going through estate recovery, and without being touched by the state. The reason most lawyers do not mention this is simple. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to set up correctly. A standard will cost $200. The older adult walks in asking for a will. The lawyer sells them a will, and the conversation about long-term care never happens. Therefore, you must walk in already knowing the right phrase. You must say the words Medicaid Asset Protection Trust out loud. And you must ask whether you qualify, and you must do it at least 60 months before any care is needed, because the 5-year clock does not start until the trust is funded. Here is what to do this week. First, pull every bank statement from the last 60 months and look for any transfer over $500 to a family member. Make a list. You need to know your exposure before you talk to anyone. Second, find a lawyer who is certified in elder law specifically. The certification is called CELA, which stands for Certified Elder Law Attorney. A general estate lawyer is not enough. You need someone whose entire practice is built around Medicaid planning. Third, ask that lawyer by name about a Medicaid Asset Protection Trust. And if you live in Florida, Texas, Michigan, West Virginia, or Vermont, also ask about a ladybird deed for the home. Fourth, get the trust funded immediately, because every day you wait is a day added to the back end of your 5-year clock. Fifth, tell every adult child in your family to read this exact same information, because the regulation does not just affect you. It affects everything you plan to leave behind. The 5-year clock starts the day the trust is funded, not the day you decide to plan, not the day you call the attorney, the day the assets actually move. Therefore, the most expensive day in your life is the day after you should have started.